I would say that I think what everybody said is that being prepared is really very important, and you can't be prepared the week before the examination. You need to be prepared all year long. Most firms know what their problems are, whether it's one particular broker or all of your brokers, in the way that you're training them. Throughout the year, one of the fundamental points any lawyer knows is mitigation. In order to mitigate your damages, it's my view that of course you have to do the proper supervision, but from a regulatory standpoint, you have to document that supervision pretty vigorously. And I think that documentation should certainly be passed by outside counsel or inside counsel to make sure that conflicts of interest and problems don't arise relating to that supervision. Because as soon as the regulators get on the scene, as soon as that first letter comes in, I mean, one of the things we talked about earlier that I think is the biggest problem out there is the conflict of interest. Because you've got a supervisor then pitted against the broker saying, he never told me I shouldn't do that. The supervisor said I sat him down 3 times. If you had memos documenting the 3 times you sat him down, and maybe you put him under special restrictions for a period based upon the prior conduct, then you can say to the regulators, look, I did it. He was intentionally hiding his actions behind my back. I did all that I could do. And you're going to save the supervisor in the firm, and then you're going to show that the broker is the problem. I think one of the most crucial things that regulators need to do from the get-go, really, is to look at and to really adequately describe to people, especially, we'll talk about later on in record interviews, but, you know, what conflicts really are, and really fully disclose that, because I think that's where a lot of problems really start. And I think that you really have to adequately document supervision, because I've represented a number of supervisors and compliance officers over the years, and everybody says, well, we had this meeting and we had that meeting, and nobody can remember all the meetings, nobody can remember all of these corrective actions that were requested of the broker. But if you document these things, then you're in a much stronger position to say, I have a supervisory system reasonably designed to maintain and enforce rules and regulations, because the standard is very amorphous.
I'm sorry, but don't you then document the case against you because won the person 3 times and done nothing about it?
Well, you have to do something about it. I mean, if you're not going to do something about it, then you are participating in it. So, you know, I mean, if you truly want a good supervisory system, you have to put it there. I mean,
and carry it out.
And carry it out.
Quite honestly, I personally came across a situation like that where that did in fact happen, but that was in essence what saved the supervisor. And so when it came where the rubber met the road and we were going to name an individual, we simply named the broker, because we felt that, and it comes down to a question of adequacy.
Did you name the firm?
Were the steps taken adequate?
Did you name the firm?
Did we name the firm? I don't recall. It's quite possible that we did not, because we felt that the systems in place were adequate and that the necessary steps were timely and were designed to supervise the individual appropriately. And we looked at that very hard.
Because I've had that situation just now where I've gotten Wells notice in a case where the attorney at the association